Well, good afternoon and welcome to this afternoon's panel on the evolving roles and the regulatory oversights of intermediaries. Um, so, what are intermediaries? Let me give you a preview of what we can look forward to, right? In 1995, I think when most of us uh, uh, think of how the internet began, one of the big things that was really that caught everyone's attention back then was this concept of disintermediation, the removal of the intermediaries. We started going online to book hotel rooms directly. We bought our airline tickets directly, right? We were so happy that we didn't have to work through an intermediary. Well, back then, right, intermediaries that we were familiar with were like your web directory services, your ISPs that hosted or provide links to other places, and search engines that back then didn't really quite sell advertisements. Fast forward to 2021, we are seeing a phenomenon, a replacement, a reversal, a movement from disintermediation into a world where we have many new types of intermediaries. And the role of intermediaries in these two-sided markets that they operate in are also starting to evolve. We have e-commerce platforms, we have search engines still, we have social media platforms these days, and of course, during this last 18 months for many of us in this region, we are using apps for food delivery, apps for booking travel, and for making hotel reservations, and even to some, right, app stores are also a new type of intermediaries. The market dynamics have changed. The neutral role that intermediaries once played and their dependence on neutral automated processing has evolved. Intermediaries today often have a stake in and also participate in the market that they operate. For example, AdWords, right, as advertising for collecting, selling advertisement for searches, right, ranking prioritization, so that affiliates, right, rank higher when you run searches, right, or sometimes for a payment of fee, and also having an interest in taking a commission from digital payments when you run an app store. These are some examples of how intermediaries now play a role in the market. For the next hour and a half, we will take a stroll through history and we will discuss how the roles of intermediaries have evolved and how their past immunities and the safe harbors are starting to also change. I have the pleasure of inviting first Professor Chris Reed. He was there when I began this journey, and I am very glad to introduce him today. He will give us a quick overview of this whole landscape, a quick skip over 25 years of history, and he will end off by giving us a bit of his comments on how things are evolving right now. Professor Reed, over to you.
Right. Thank you, Zeke, and that's very kind. You said we're going to do a stroll through the area, and when you asked me to do this, you said, "Will I look at the history of the last 26 years?" And you've only got 15 minutes, so we're not going to stroll. We're going to sprint through the last 26 years to try and bring us up to date. So I guess we need to go back to 1995, when probably most people here weren't doing anything in the area, but I'd been around for a bit by then. And just think about what happened. If we can go to the first slide, please. The next one, sorry. Okay. Next slide. Yeah, thank you. Right. So where do we start? Right. Well, we're back in 95. The modern internet has just appeared. It stopped being a defense and research network. It's been opened to the general public and to commerce. And so, of course, people start piling in to do things. And at that point, as Zekin has said, intermediaries were very passive people. They were part of the fundamental infrastructure. So they were the intermediaries which carried data between one place and another. They were the intermediaries which stored or hosted the early websites, and so on. We didn't even have search engines. They didn't exist. We had the Yahoo directory if you wanted to find stuff online. So at that point, intermediaries were very passive. They didn't do anything other than carrying stuff or hosting stuff. That's all they did. And they were part of the fundamental infrastructure of the internet. Without those intermediaries, the internet wouldn't exist. Now, the problem that we had was almost immediately there were a number of lawsuits against particularly internet service providers, the people who gave you access to the internet and who ran the backbones that connected everybody. And the one that really caught everybody's attention was Religious Technology Center against Netcom in California in 1995. Religious Technology Center is the company which owns the Church of Scientology. They wanted to keep various documents secret, but somebody who had left the church and was unhappy with it wanted to share those documents around, and did so via a technology called newsgroups, which most of us have never heard of. But it was just a way of spreading information around the internet. RTC, the Religious Technology Center, wanted to stop this, and so it brought an action against Netcom. Netcom ran the US internet backbone. So every piece of information running along the internet in the US had to pass through Netcom systems. So obviously it would be copying stuff, because that's how computers work. You copy things from one computer to another, which is how you transmit information. So it was a copyright infringement suit brought against Religious Technology, against Netcom. If RTC had won and had got an injunction to stop Netcom from carrying any of this information, it would effectively have shut down the entire US internet, because there was no way that Netcom had any idea what it was carrying. It just knew, here are packets of data, we're moving from one place to another. So the courts, realizing this, came up with quite a cunning distinction. They said, well, there's copying and there's infringing copying. There's two different kinds of copying. An infringing copying is where you have some knowledge that what you're copying is infringing, and the other kind of copying, which doesn't count, is copying which is purely automatic and you've no idea what's going on there. So everybody breathed, but it was obvious that this might not work in other cases. It might not work for defamation actions. It might not work for trademark infringement suits. So there was a real problem. Lots of articles written about how we deal with it, but no solution. So as a response, lawmakers introduced intermediary immunity, initially rather by accident in the US Communications Decency Act, because it was trying to control pornography and other undesirable expression. And lots of that was struck down as unconstitutional, just leaving the immunities. Singapore followed very quickly with its Electronic Transactions Act, which gave an immunity, but with the possibility of giving notice that we have unlawful material and taking it down. And then we have the EU Electronic Commerce Directive, which I see I've misspelt, and that took the same approach. So the idea was there's a complete immunity for all those online actors who just transmit information or carry it around the internet, and a kind of qualified immunity for those who host it, people who host websites, for example. That is, if they got notice of unlawful content and didn't take it down, they could have some liability. Their immunity could be lost. So it was a very simple black and white thing. If you're an intermediary, you have no liability unless you're told there's a problem. Okay, next slide, please. Now, the problem with that was that it's too absolute, and it immediately created lots of new problems. So some intermediaries took the view, I mean, very sensibly from a practical point of view, that the best thing for us to do is to ignore harmful content completely. Because once we know about it, we have a problem, and so we don't want to know about it. And so, for example, in 2001, you have the US case of Doe against AOL. A young boy had been targeted by pedophiles. They took sexual images of him. They shared them online, and AOL just refused to do anything about it, in spite of lots of contacts asking them to take this information down. And the court said, nothing can be done. They have immunity. If they choose to do nothing, that's their choice. A second problem was that it enabled wrongdoers to hide behind intermediaries. This was particularly a problem on, say, eBay, where you had lots of sellers of counterfeit products, particularly high-end fashion goods, handbags, that kind of thing. They all infringe trademarks, but because these people are part of the eBay system, because they're not really properly identified, yeah, they were hard to find. They were obviously liable for infringement, but you couldn't find them. And eBay itself was an intermediary, and so eBay had no obligation to do anything about all this counterfeiting that was going on. And the courts have had goes at dealing with this. The European Court of Justice in L'Oreal and eBay tried to nuance the immunity, saying, well, you know, if eBay is not just being independent, but is helping people with their businesses, maybe we could make it liable, but it's still terribly vague. In some cases, the courts tried to use injunctions to reimpose liability. In the Scarlett and Sabam case in Europe, Scarlett is the main Belgian internet service provider. Sabam is the organization which represents music rights owners. And it was worried about music piracy online, unlawful copies of songs. So it got an injunction in the courts against Scarlett saying, you must make sure that you don't carry any infringing copies of our music. Now, that was struck down by the European Court of Justice because it was too wide. It effectively took away the immunity, and also it interfered with the fundamental rights of Scarlett subscribers because all your information would now be monitored, and it also interfered with Scarlett's rights to run a business. But, you know, you can see what's happening here. There are problems that nobody thought of in 1995, and the courts are looking for ways to deal with them, but none of these ways work really well. So over recent years, we've particularly seen very strong political pressure for intermediaries to do more to counter wrongful and harmful content. You will all have heard politicians on television or radio saying, yeah, Facebook must do more, Google must do more. They never say what more means because they don't know what it means. They just want something to be done that reduces the level of wrongful and harmful content. And some states have even started trying to regulate for some kinds of content, but they're doing different things. So Germany now has a notice takedown for hate speech. France got very excited about election misinformation, so it has got a law about that. The UK is developing a law about very broad harmful content, which is currently not at all defined. This was sparked off by suicide sites and anorexia information sites, which particularly focused on young women and led a number of them to have problems or even to kill themselves. And we don't know how the UK law is going to develop, but it's going to be a much wider sort of notice takedown system with some kind of pre-monitoring happening as well. So the world is trying to do something, but it doesn't really know exactly what it ought to do. So if we move to my final slide, please. Where are we today and where do I think we're going? Well, today, I think I can see two main areas of regulatory action to try and deal with the position of intermediaries. One focuses on these immunities that we're talking about. And a very good example of that is the proposed EU Digital Services Act, which is currently still at the proposal stage, just proposed earlier this year. I guess it's going to take 2 or 3 years to become law, if it ever does, because it's quite a controversial proposal. But what it tries to do are three main things. Right. First, it restates the existing immunities. So if you are hosting material, then you are not liable unless you have notice and fail to do something about it. If you're just carrying the stuff around, you have no liability at all. But it does clarify some of the questions that have come up about the edges of these immunities. I don't want to go into that now, but it's fairly simple stuff. Right. And that's obvious, you know, it's worth doing, right? But the second thing is it's now going to impose new obligations in respect of illegal content, particularly obligations to act on court orders against specific items of illegal content. Now, to be honest, that's already the law in most countries in the EU and still in the UK, but that could change, and the courts do take different attitudes to different types of legal claim, and they also take different attitudes to how far things like your fundamental rights might provide a reason for not granting an injunction. So this is designed to clarify the position and make it clear that in all cases, if there is an order by a court or a proper administrative body to do something about a specific item of content, then the intermediary must act. Now that's very similar to what we have at the moment. The new stuff applies only to what are called very large platforms. These are platforms that I'm going to have to look up the numbers here, which I wrote down. Yes, those with 45 million or more users, or those with very high level of turnover. So if you're a platform like Facebook or Google or eBay or Alibaba, any one of these very large platforms with lots of users, then you have extra obligations. And those extra obligations basically consist of monitoring for illegal content and to some extent moderating it. Now, it's not quite clear yet in the proposal what that's going to mean, but it's clearly going to mean advance action to try to cut down the level of illegal content. This is very much focused on illegal content, not undesirable or harmful content. So there's quite a disconnect here between what the EU is doing and what the UK plans, which is potential to go all the way to things that are perfectly lawful, but for some reason society doesn't like, right, which is a clear clash with the rights of free speech. And then the other things that the big platforms have to do is to be transparent. So they have to give reports about what they're doing, about how their advertising is working, and what the rules are for ranking stuff and putting adverts against it. And they're also going to have to implement mitigating measures against all the risks that they do in this risk analysis. So that's the intermediary immunity area. Right? But the other thing that's happening, and this is really comparatively recent, is that competition law is suddenly coming into play, because we have a very, very strong concentration. Yeah, I don't know the exact numbers, but Facebook and Google between them have more than 90% of the online advertising market, I would guess. It really is a huge concentration that's been happening in the intermediary space. And almost by definition, when you get very big as a business, you find it very hard not to act in a way which is anti-competitive. So we have a number of competition law actions. In the US, we've got antitrust law actions. We've got the Apple and Epic decision about the game Fortnite, which is about Apple making Fortnite insist on payment through the Apple Store and not directing people to different ways of paying for in-game content. We've got the Department of Justice against Google, suggesting that Google is a monopolist in search. The FTC is investigating Facebook for all sorts of things, but particularly privacy infringements. And there's a new competition antitrust law enforcement reform bill which is going through, which will actually give the authorities resources to do more antitrust investigations. In the EU, we already have the platform to business fairness regulation, which is really just about transparency with intermediaries so that businesses know the rules and the deal and the terms and how much they have to pay. And there's a proposed EU Digital Markets Act, which is very interesting because that's going to identify gatekeepers, these very large platforms I was talking about earlier, and is going to develop a new and bespoke competition law regime just for them. So that's where we are at the moment. What might be next? Well, that's very hard to say, but the pressure is still there to make intermediaries do more and to focus beyond illegal content to content that society doesn't like. And here we have a huge clash between that and fundamental rights like privacy and free speech. And maybe we'll talk about some of these issues in the discussion. I've run over by 40 seconds, Zeke, and I do apologize. Thank you.
Thanks, Prof. Reed. And I think you managed to really give us a very quick overview, a sprint right through history, and what's been happening across both sides of the Atlantic. Now, over here around Asia and the Pacific, right? I've got my fellow panelists, right, and I will call on them each, right, to give us a bit of a similar sprints on what's been happening over the years. I'm going to go in alphabetical order, right? And alphabetical of countries, right? And I'm going to start with Royce. He's with Alibaba, and he's going to give us a bit of a update on what's been happening around this space involving intermediaries in China. So Royce, over to you, please.
Thanks again. Very happy to be here to have a chance to discuss with everyone the evolution, the law on platforms in China. Professor Reed finished his presentation with a very pregnant question in terms of what comes next. I think the answer is quite clear in so far as China is concerned. I think clearly the halcyon days is very much behind us. And we can expect to see more enforcement actions, more in-depth regulations on platforms in China. All right, so this slide just gives a very broad overview in terms of the timeline as well as the key regulatory and administrative interventions in China. So if you take a step back and you look at some of the laws that applies or has an impact on intermediaries or platforms in China, we can start off with the tort law, the People's Republic of China, as well as the regulation and protection of the right to communicate works to the public over information networks. These are very minimal, I would say, very light touch regulations in terms of the core functions of platforms themselves. And then if you look at the arrows as represented by the timelines, things get a bit more serious when it comes to the anti-monopoly law. So there are provisions there which do apply to platforms. Then you also have the e-commerce law, which deals with some notice and takedown requirements. So far, this will be pretty much aligned with the earlier iteration, the earlier era of a more light touch approach to internet regulation. But in this year, 2021, we can see an epochal change, I would say, not just in terms of tone, but also in terms of the form and the substance of the regulatory regime that applies to platforms such as that of Alibaba. So we start off with February of this year, where the State Council or the Cabinet of China issued the guidelines for the platform economy. So I'll just touch very briefly on some of the more salient aspects of these guidelines. So for the first time, for instance, it mentioned what is known as a hub and spoke agreements. These are essentially a situation where different merchants or operators on the same platform, they may reach an agreement or an understanding that has the effect of horizontal monopoly agreement by using the vertical relationship with the platform operator or by the organization and coordination of the platform operator. The other key aspect would be what we call the MFN clause or most favored nation clause. So essentially what this means is that if a platform operator, we require merchants on that platform to provide us with better trading conditions, including such as price or quantity compared to other platform operators, also the so-called MFN clauses, such requirements might then be considered as both a vertical monopoly agreement and possibly an abuse of dominance. Another conduct that has been singled out via the guidelines is what is known as the 二选一 or choosing one from two. It's a very popular phrase which describes the situation whereby one platform operator forces the merchants to exclusively choose its platform, failure of which the platform may penalize the merchants, such as downranking its search results or via higher prices of its products and services. So the guidelines today clearly state that such a practice could be challenged as an abuse of dominance. Another issue that's been singled out is what is known as the big data discrimination or 大数据杀手. So apologize for my poor Chinese. So essentially, this is a case whereby a dominant platform operator may be deemed as abusing its dominance by discriminating towards its users. So this can be borne out, for instance, if the platform operator implements differentiated prices or other transaction conditions based on the use of big data and algorithms, based on in accordance with payment capacity of the user, the consumption preference, the usage habits, etc. of the users. Although there are also exceptions whereby the platform operator will be given an opportunity to provide legitimate reasons for such discriminatory treatment. I then move on to the next aspect, which is the measures on the supervision and administration of online transactions, issued the following month in March of this year. This will be issued by the SAMR. So one key regulation is revolves around consumer protection. So for the collection of sensitive data of consumers, we need to get the consent on an individual basis or separate basis, including the collection of biometric information, the financial data, and the tracing information of the consumers. For marketing as well, we need to get the prior consent of the consumers. We have to clearly indicate the identity and the contact information and provide a prominent, simple, and free way to unsubscribe to marketing. And once we receive any instructions to stop sending the marketing materials, we have to do so as soon as possible. And for automatic renewal of services, similarly, we need to remind consumers 5 days before the start of the renewal. And again, to provide a simple, free way to cancel at any point in time. Platform operators are also clearly proscribed from any false or misleading commercial advertisements, such as to create a fabricated panic purchasing, clickbaits, the manipulation of fake positive comments, and conversely, the suppression of negative comments on the platforms. And then move on to the draft provisions on prohibited acts of unfair online competition. I'll just touch very quickly on one aspect of that, which is the prohibition on the use of technical measures to obstruct or to disrupt the legitimate business operations of other businesses. So we might not, the platform must not use data, algorithms, or other technical means to influence user choices, or use other methods to carry out conduct such as traffic hijacking, interference, or malicious incompatibility that may obstruct or undermine the normal operation of network products or services that are legally provided by other business operators. I then very quickly touch on the PIPL, which is the general data protection law that was recently passed by China's legislature. Some of the more relevant aspects when it comes to the operation of platforms includes automated decision-making and profiling. So we need to provide very clear option for consumers to opt out with a one-click setting. For facial recognition in public places, again, this is one issue which has garnered a lot of strong feedback from the public. So under the PIPL, it's made very clear that this is a very tightly regulated area. You need to have obvious notification, and the collection and use must only be restricted to public safety purposes unless we can obtain separate individual consent. And then the very last one, which is the proposal to amend the e-commerce law. So this puts the focus back to IP infringement, which one might argue is the very genesis of a lot of the moves towards regulating platforms. So here, under some of the draft changes, there'll be higher penalties, including possible license revocation for serious offenses. It is also made clear that e-commerce platform operators might be made jointly liable along with the merchants for selling counterfeit or otherwise infringing products whenever that operator or service provider knows or should have known that a party on the platform has infringed other people's IP, but fails to take the necessary preliminary measures to counter the infringement. If we can move to the next slide. So having done a very, very quick overview of some of the key changes that have come on board or will be coming on board, I think it's useful to also take a step back to try to see what this portends for platform operators like Alibaba. So first, quite clearly, this represents a clear, rapid increase in the number as well as the degree of regulations on platforms. And it's useful not to adopt a very siloed approach, but rather to adopt a more holistic approach to understand that many of the behavior or concerns being targeted by the various measures, they really span across the entire gamut of concerns from data protection, privacy, antitrust concerns, consumer protection and welfare, national security, etc. And it's also noteworthy that in the current milieu, it's really a usage of a mix of both, not just hard law, but also soft law. Especially in China, I think a lot of the regulatory impetus may arise out of policies and guidance issued by SAMR as well as the other enforcement agencies. Another point to note is there's a difference between central and provincial policies and enforcement. I think from past experience or history, one can see that different provinces might adopt varying degrees of regulations as well as the types of or the pace of the enforcement actions. While the jury is still out as to what the new changes may mean, I think one likely trajectory is that we can see greater centralization in the sense that the SAMR may play a more central role to, I wouldn't say dictate, but really to set the tone and to set the pace for the provinces to then follow. So one can expect a more coordinated and a more synchronized approach, one that minimizes the possibility of regulatory arbitrage. It's also important to really contextualize what is the essence in terms of the role and the value that platforms provide. I think in the development of the digital economy, sometimes not so, this discussion may not admit of very clear answers, especially as platforms develop other goods and services and reach out into adjacent fields. So considering the change in the regulatory environment and the temperature, I think it's useful to then remember what is the core role of the platform in connecting buyers and sellers and in providing that useful service to allow transactions to close off more efficiently and more securely. It's also important to go beyond all the rhetoric and all the legislative text to really understand what is the spirit that animates a lot of the actions undertaken by the enforcement agencies. So what are exactly the state's objectives? And I think this can be summarized into a few key points. I think one is how do we further promote the growth of SMEs? How do we increase innovation? How do we then improve and further protect consumer autonomy, choice, and control? Not forgetting also, very importantly, safeguarding the worker wages, the workers' welfare, and of course, national security. And one last point I would say is that I think when it comes to in-house counsel, I think compliance adaptation would definitely be key for the continuation of the right to business, in order the maintenance of the license. At the same time, it's important to do so in a very agile fashion to be able to come up with compliance programs that takes into account the state's objectives and to design solutions that will satisfy the concerns of the regulatory agencies. I think that's the best formula when it comes to long-term resilience and sustainability of our business. I'll end my sharing here.
Thanks, Royce. And I don't know whether the rest of the audience found themselves a little bit overwhelmed by the speed, pace, and the volume of changes that happened this year. But I think what we can see is that this is a hotly contested area. Things are happening by the month, right? And one of the things that struck me as we were listening, as I was listening to the sharing of Professor Reed and Royce, is that yes, we have made that transition. I don't think it's a question of whether we are or not. We have made that transition, right, from where intermediaries were given immunities and safe harbors because they were neutral and they didn't know what they were carrying, and where they had no obligation to monitor. That has changed, right, in a need to act. And in the examples from coming out from China, where they are also participating in the markets, the two-sided market that they host, there are trading practices, right, that needs also to be looked at to make sure that these trading practices are fair. Now, I would now like to hand the mic over to Malavika, right, who will give us a view of the developments in this area from India.
Thank you. And it's actually great to come right after that, the previous talk, because I think a lot of the developments in India do seem to be catching up with the global kind of consensus that not just around intermediary regulation do we need to move, we also need to look at kind of competition and other aspects, especially around e-commerce regulation. So what I'm going to do in my talk, if we can go to the next slide, is just spend the next 4 minutes, again, just on two very broad areas. I think the big ticket development that everybody is watching in India right now, of course, is the most recent rules that we've had that dramatically have shaped or reshaped the safe harbor. As Professor Reed spoke about, we have similar types of safe harbor logics in India, but that's really, I think, the growth of large big techs in India and intermediary platforms, both for messaging and sort of social media, but also for e-commerce and other kinds of activities outside of primarily just kind of communications, is raising a challenge to that. I've also put here section 79 is where our safe harbor resides within the Information Technology Act of 2000. But as you can imagine, things have really changed since the year 2000. So the idea of an intermediary that is regulated by the Information Technology Act primarily deals in India with this idea of transmitting or storing records. And therefore, because of the passive or dumb pipe nature of that intermediary, a lot of the regulation there is around the passing of information itself. And I'll come back to that and why that's important. I think the other big section that has come into play a lot is, I've put there 69 and 69A, which used to exist as well, which is really around content blocking. It was initially set up for kind of illegal content or the kinds of content that we talked about, pornographic content and things that might, cause international relations problems, defense problems. But that's also being widened. And anyway, we'll do a bit of a deep dive in terms of what few areas that I think are relevant for this discussion. I think the other axes of regulation, though, outside of where we've traditionally placed intermediary regulation, that are moving quite quickly. And like I said, we've not progressed as far as China seems to, but around 3 or 4 areas of regulation that lie outside the Information Technology Act, which you see on the slide there, which I'll also touch on. As I said, we could have multiple talks on each of those areas of regulation, but I just thought what would be useful for this audience is give some of the highlights of where things are. In many cases, they have not come to fruition, so we do not have a full spectrum law yet, but there is regulation or court matters or competition investigations in play. So if we go to the next slide, what I was thinking of spending perhaps a minute on is just giving you the broad contours of what's changed in the safe harbor. So as I said, the safe harbor in our parent legislation just says that to claim this intermediary, you must transmit information. You must not actually have any role in selecting that information or modifying it in any way. And then, of course, you have to undertake some due diligence. And really, this is where the tension really comes, because as we see, more and more evidence that these large platforms are not merely just sort of neutral, passive intermediaries, but actually have a role in the curation of the information on there. The question is, at what point do we need to revisit how we think about safe harbors and the conditions itself? One way to trying to resolve that conflict about, can you not play at all a role in the transmission of that information, and perhaps you have automated means which do that. One way that we're trying to resolve that conflict between that condition and claiming the safe harbor itself is by putting in additional due diligence requirements, and that's what's happened under this digital media ethics codes. What I'm not touching on is the bottom of the slide. You'll see there's an entire new part which was brought into these intermediary guidelines in India earlier this year, which never existed. So in the part 2, essentially, we broadened out the due diligence measures required to claim the regulatory safe harbor. But what happened also is we included a completely new set of regulations that actually widen who intermediaries are. And that includes actually news media as well as over-the-top players such as Netflix and so on that provide online curated content. So we're calling them publishers of online curated content and bringing them into intermediaries, the definition, which is again a larger legal question about can we do that through regulation, or do we really need to go and revisit our law itself? But be that as it may, these rules are in effect right now, and they actually the 3-month period for compliance expired in June, which means several large intermediaries, and Twitter has been in a kind of Twitter war, ironically, with some of the ministries in India talking about what are the implications of them not technically complying with some of the requirements, and whether they are therefore will become a party to many grievances. That's already starting to happen in some cases. The three specific types of due diligence I thought quickly I'll just highlight, and happy to come back. One of the requirements now for a new category of subcategory of intermediary called a social media intermediary, or significant social media intermediary, notified to be anyone with more than 5 million users. And that's quite low because WhatsApp has 400 million users in India currently, or perhaps more. One of the things that WhatsApp has filed a case against is that there is a requirement for a traceability of a first originator of any message on their platform. And the big privacy challenge here is that if you need to do traceability for one user, you need to implement it across the platform, and that denudes the privacy of all users. So that's a constitutional matter that's going to be quite interesting to watch. Another requirement is automated content screening. Again, this comes interestingly from constitutional and Supreme Court cases that have really taken a strong stance around the circulation of child sexual abuse material online and the impact on society and so on. And so now there's this new rule that actually requires actively screening your content, which could again go against the logic that there is a passive intermediary, or you do not actually, interfere with the content on your platform. And then lastly, very interestingly, a lot of these regulations now require resident employees. I think this also plays into the larger international relations dynamic here, that many of these platforms are not Indian platforms, and they therefore have, often you go to enforce as a local authority, and there's really no way to enforce because they often say, we've sent it off to the US and so on and so forth. So I think there is an interesting regulatory impact of the political climate. And I think the thing that I haven't mentioned here, which is again also under challenge in the many constitutional cases that have been filed in the last 2 months, I think over 20, maybe 14 to 20 in the last 2 months, is that there's also a new regulation for emergency blocking of content. So that creates again a tension between the 69 provision we just spoke about, where you have blocking of content for national security reasons. But this almost seems to be a different kind of blocking of content to deal with disinformation, misinformation, this kind of, child sexual abuse material and so on. And the question, of course, is then it creates all these tensions around freedom of speech and how can you actually privatize the policing of a fundamental right? So in effect, by placing these obligations on, say, Facebook, Twitter, and so on, they are actually adjudicating on an Indian's fundamental right. So these are some of the deeper issues. I'll quickly just jump on to the next slide, where I just wanted to highlight, we don't have the time to go into each of these movements, but I thought it would be very useful for this audience. At a very high level, I think while the intermediary regulation conversation has been primarily about communication and data use and taking down content and so on. Meanwhile, there's been a lot of anxiety on the economic side of what this means. And I think one large area where that's playing out is actually e-commerce platforms. Amazon, actually Flipkart, which is the national sort of homegrown variety e-commerce platform, and several others who are now offering goods and services, for sale. There is a new set of rules that came out last year called the Consumer Protection E-commerce Rules. Very interesting because they have now for the first time used a consumer protection lens to define what constitute marketplace or inventory-driven entities, and almost placing them as a new category of seller, for instance. So there's a recognition that you have these two-sided markets. Sellers themselves are consumers in some sense. And so what can we do to ensure that both sellers on these platforms as well as consumers have do not face unfair trade practices? So this is quite interesting, a little kind of FTC style expansion of what we have thought about as unfair trade practices to also include things like arbitrary classification of consumers. And this might be when you are providing search results and so on. And also, of course, manipulating prices and searches. So quite interesting provisions. They are very extensive rules. I've just picked out their couple, which are again relevant to this conversation, but they place an entire set of duties and liabilities on sellers and rights for consumers previously, which did not exist. Interestingly, we are in the process of proposed amendments to the 2020 rules, which shows how fast this moves, which are almost asking for sort of bans on flash sales and deep discounting and so on. That's been quite controversial, and we'll see where that lands. Another very controversial document was the National E-commerce Policy, which I understand a new draft of is due anytime. And here we actually, what we saw happen is a policymaker's anxiety around the data on these platforms. So one side is the commercial practices, but this was really about data. And again, if I had to summarize in a nutshell, I think one of the things the policy tried to do is make a very clear stance that data collected from Indian users and data collected in India, even if it's collected on these e-commerce platforms, there needs to be some way to harness that resource, as well as ensure that it's not leveraged in a way that's anti-competitive to local platforms or local sellers. And in sense, the power of the sales relationship being mediated through this data platform was being recognized there. A connected thing that's kind of a segue into all of the competition proceedings that are, as I mentioned, quite early days yet. So we've had, for instance, I would say that one of the most significant interim orders we have had is really in relation to Google and Alphabet, where there was a sense that the investigation was started and there was a prima facie hearing in that investigation that Google actually, by mandating the installation of the GPay app, and also on its Android interface, was actually able to protect its position in other markets. So that's quite an interesting case that's live right now. Another thing, of course, is very recently, I think a couple of months ago now, the first one was a suo motu investigation. The second one is actually a complaint filed by a nonprofit, which was challenging Apple's in-app purchase fee. And again, we wait to see what is the interim order in that. Separately, perhaps we can get into this in the conversation. There are two other matters. One is actually in relation to WhatsApp. So this is quite interesting. It's not really on e-commerce, but what's happening is for the first time, the change in the privacy policy of WhatsApp, which now also allows payments. The CCI, which is our competition commission, when it was looking into, again, suo motu taking up this case, thinking about whether privacy is a non-price parameter of competition. And again, live in play, we don't know what's going to happen, and it's actually the jurisdiction of the Competition Commission is being challenged in the High Court. So something there to look at. And then, of course, we have a bunch of small and medium sellers who have also raised, a Competition Commission case against Flipkart and Amazon, but we can maybe deal with that in the discussion. And I suppose the last comment I will make is really that in the background of all this, we have some data regulation, system-wide data regulation that's coming out. That's, of course, our draft personal data protection bill, which we expect, in the next, every of the last 4 sessions of Parliament, we've expected to come into Parliament, and this time they think it might really happen. And of course, there are 2 areas which are quite interesting for this debate. One is that we do have a new provision around cross-border data transfer restrictions. And many of this deal with that similar anxiety about sensitive data or commercially important data of India not being harnessed by local players, but also this inability for enforcement officials to actually enforce when that data is causing some kind of national distress due to fake news, etc. One of the things that is already in play is that our central bank has mandated data localization for payments data. And that is already in play, has been complied with. And what we mean by data localization is a mirroring, in some sense, of financial data in India. And the last thing on that slide there is also, there could be a new concept of a significant data fiduciary. It's quite new. It's something like the information fiduciary concept, I think, that other scholars in the US have talked about. But if we have that come in under the data protection bill, very much these large internet intermediaries are now not just talking about safe harbor and the law around that. They are fighting multiple battles on multiple fronts. And I think really that comes back to the original question, is that we're not in 1995 anymore, Dorothy. Intermediaries have changed significantly, their impact on society, how they function. And I think on that note, I'll hand it back to Zeke. It's a very quick canter through, and I'm happy to answer any questions.
Thanks, Malavika. I think that it was a fascinating presentation, and I wanted to just pull out 3 things so that we can pay attention to some of these common trends and new or rather intrusions into new territories as we go through our country review. I think, again, right, content screening. Again, it goes back to this principle that we had before. Previously, no duty to monitor. Now, over time, a certain expectation to react. Now, a certain expectation to act on complaints, and now screening even, right? I think that really shakes at one of the fundamental pillars of intermediary immunities and safe harbors. The other thing as well, right? something that struck me as I was listening to your presentation. Again, intermediaries were defined because they were neutral and they were just passing data along, right? And it was a fairly automated process. But today, is it neutral? We are talking about data being used in recommendation engines, right? And different types of ranking or ranking affiliates differently. Yes, these might still be algorithmic, automated, but are they any neutral anymore, right? And finally, you opened up a new area, data access, and that's one of those things that I think is going to come back again as we talk about this, right? Understanding that now intermediaries sit on data, and data is an important input, right, factor for production in the industry, in the fourth industrial revolution, right? So how do we ensure equitable access, equal opportunities, and also safeguard domestic economic stability, right? Now, with these points in mind, I'd like now to hand the mic over to Takashi, right, who will give us a bit of a sprint as well over the developments that's been taking place in Japan. Over to you, Takashi.
Thank you for introduction. Today, I'd like to explain about three issues about evolving situations about internet intermediaries in Japan. Please, next slide. At first, I'd like to intermediary immunity. Typical case about intermediary liabilities is in the context of a trademark act or copyright act in Japan so far. So, but the copyright act and the trademark act does not say about especially about the liability of intermediaries. So we introduced the new act, but it's around 12 years ago. This second point, Provider Liability Limitation Act. The act name is very long, but actually it consists of 4 articles just only. And this is a law about immunity of liability immunity, and also it's okay to disclose the sender's name to the public in some situation. So for around these 20 years, we have now we focused our intermediary immunity discussions under this Provider Liability Limitation Act. But these days, in Japan, there is a big trend about the intermediary business. Not only a trademark, not only social media and movie platform, but also to online shopping and the search engine and the advertising market, digital advertising market. So please, next slide. This is the second point. So there is an imbalance between online shop operators, each operators, and online shop platformer providers. In that situation, there is some imbalance in those powers. So, but it is difficult to regulate such situation by the Anti-Monopoly Act in Japan. And some people criticize Anti-Monopoly Act maybe apply to that situation, but it's just ex post regulation. I mean post regulation. So it is not effective to regulate such a situation. So Japanese government decided to introduce the new act. The name is the Act on Improving Transparency and Fairness in Trading on Specified Digital Platforms. We call it as a TFDPA. This was enacted in 2020, last year, and went into effect on this February. So this is a very new act, and also the scope of the new act applies is very limited. Now this is only two markets. I mean, online shopping market, online shopping malls market, and also online application stores market. Yeah, I write that point in this two second item. So also this act is governed by METI. METI is the name of the government department, the Ministry of Economy, Trade and Industry, and not JFTC, Japan Fair Trade Commission. So you see many guidelines issued by METI in Japanese at the METI websites. And also the scope is very limited, and the government is considering to expand the scope of this TFDPA to additional business areas. Please, next slide. Thank you. This slide explained about this definition of digital platforms to be regulated under this TFPDA. And as you see, they have now 3 points in the discussion in this definition. First point is that they provide places, and the second point is that they provide services via the internet. And also the third point is that they provide services utilizing network effects. So actually, please, next slide. Thank you. Actually, among these platforms definitions, item 1, 2, 3, those particularly required to improve transparency and fairness to be stipulated specified digital platforms by a cabinet order. This cabinet order is specified by the METI. At first, they designate these two areas. First point is first market is business to consumer online marketplaces, with annual sales in Japan measured from April 1 to March 31 of at least JPY 300 billion yen. It will be equal to 3 billion US dollars. And the second market type is business to consumer application stores, with annual sales in Japan at least JPY 200 billion yen. It means 2 billion US dollars. So the scope is the business is to be regulated under this TFPDA is very, very limited, as you see. Please, next slide. But as I said, the Japanese government intends to expand the scope to be regulated under this TFDPA. Actually, the Japanese government Secretariat of the Headquarters for Digital Market Competition Cabinet Secretariat Japan released the report, a final report in this April. This report is named Evaluation of Competition in the Digital Advertising Market Final Report. It means the government is considering to target the online advertising market as the next target under this TFDPA. But it's now in the discussion, even now at this stage. So we should watch the situation and how to proceed. The government intends to expand the scope in the near future. Yeah. So this is things are what I want to in my presentation. Thank you.
Yeah, thank you, Takashi. And I think that here we see a development in Japan, right, which looks fairly similar to the platform to business fairness regulation that Professor Reed shared with us about, that was introduced in EU in 2019. But one of the things that it's thrown up, right, is really the difference between intermediaries and gatekeepers, right? Intermediaries, we know, you run a place, a two or multi-sided platform, multi-sided marketplace. Whereas the gatekeepers is a slightly different concept, right? You don't actually need to run a place. And one of the things that I noticed is that app stores are very clearly defined as intermediaries here, whereas in the EU, right, it seems to be that they are referred to as gatekeepers and they'll be caught under the Digital Markets Act and not so much as intermediaries. But this actually highlights one big problem that we currently face now, is the concept of definition, scope, and thresholds. And that's something that I'd like to come back to. But before we get there, I'd like to invite Shuming, right, who will give us a bit of will share with us, right, what's been happening in Singapore and how we actually have approached a certain aspect of it in a slightly different way. So over to you, Shuming.
Thank you, Zikin. I will, in keeping in the spirit with this particular segment, I will also do a quick sprint. Essentially, what you do see in Singapore is a sort of microcosm, which is similar and works along the same lines as the developments which Professor Reed has mentioned. I think in the earlier days, where there was a push to encourage greater adoption of technologies, especially the services that are provided by internet intermediaries, you see an attempt to introduce legislation which provides protection to these intermediaries. And that you can see in the Electronic Transactions Act, Section 26, where basically no civil or criminal liability will apply to conduits that allow people to have access to material. And of course, there were built into it exceptions, and these exceptions related to licensing regulations. They related to laws and court orders that imposed restrictions on access to data and material, and also, of course, copyright infringement. So going now along the same line of immunity, you will see that in the Copyright Act, our Copyright Act actually does allow for protection against monetary claims to the extent that the conduit or the internet intermediary is essentially providing transmission, routing, or connection services and allowing parties to gain access to material. But in that sense, it needs to ultimately be acting as a neutral, automatic conduit. So once that is established, then no monetary liability can attach. And in the context of other kinds of functions that it performs, for example, caching, hosting, and linking of copyrighted material, we provide safe harbors. And one of the main conditions for safe harbor is essentially the requirement to take down or prevent access to infringing material if the copyright owner were to give notice. If I can just move over to the next slide, we're basically moving away from immunity and talking about some of the instances in Singapore where inroads have been made into those immunities. In the context of access blocking, you see that restrictions have been placed in the context of broadcast licensing, where undesirable, harmful, and obscene content can be blocked by the issuance of blocking directions. You see similar kinds of blocking orders in the context of the Copyright Act. I mentioned earlier that no monetary liability can attach, but nevertheless, court orders can be made under the Copyright Act, requiring internet intermediaries to prevent access to such materials that infringe the rights of copyright owners. And I think a more recent development would be the introduction of two pieces of legislation in the Singapore context. One is the protection from Harassment Act, and the second is the Protection from Online Falsehoods and Manipulation Act. And both these acts introduce disabling directions that can be issued to intermediaries, requiring them to essentially prevent access to false statements. And I think quite apart from this disabling orders or directions, you see a further positive obligation being placed on these internet intermediaries by virtue of the two acts that I mentioned earlier, to require them to also issue correction notices in response to false statements which may have been propagated through their services previously. So I think where you see there is a slight shift in emphasis, whereas in the earlier stages, we were trying to encourage greater adoption of technology, and therefore you see greater protection being given. But over time, we've realized that a lot of these internet intermediaries do potentially, by virtue of their reach, propagate certain kinds of harmful materials, and that's why there's greater interest in also balancing that the rights of parties and introducing certain kinds of restrictions. So that I think is a nutshell of where we are currently in Singapore. And of course, we are looking at greater developments that are going on in overseas jurisdictions.
Thanks, Xiuming. And I thought one of the things that I wanted to just draw out from your presentation is that I think Singapore is still pretty much at the stage where we're still we are focused primarily on immunities, safe harbors, reacting through access blocking orders when required to do so. But we've kind of like developed a new way of reacting, which is the obligation to carry corrections, right? Communications of corrections, right? Which is a fine-tuned way of crafted, right, to deal with the effects of misinformation or even disinformation. Now, thanks to all my panelists for giving us that overview, right? This is an area that can take an entire year of undergraduate or even postgraduate studies, right, to cover, and we've kind of like managed to do it in over an hour, right? In the time that remains for us, I'd like to open this up for some panel discussion, right? And I think the first thing that I'd like to open up a discussion is really to invite comments on this question. One of the things we've seen is that, as Prof. Reed pointed out towards the end of his presentation, now we see a confluence of two types of two areas of law. What has previously been essentially immunities and safe harbors, right? Some countries, like for example, the EU is taking that direction. China has taken that direction. Japan has taken that direction, right? To basically introduce positive obligations through legislation, positive ex ante obligations. Whereas in some other situations, like in the US, right, we are looking at antitrust or competition law coming in to address some of the excesses, right, in trading practices, right, in monopoly behavior. This tension. So, Xiuming, I'd like to invite you to give your comments, right? Seeing that you sit with the Competition and Consumer Commission of Singapore, what do you see are the challenges, right, in the application of competition law principles to an area like intermediary regulation, particularly as we've seen before in our presentation? What exactly are intermediaries, the markets, right, that they operate in, right? So what are the challenges that you see from wearing your competition lens? And then I'll invite the rest of our panelists to respond to that. Over to you, Xiuming.
Thanks, Ipin. I think that one of the issues that is really coming to the fore, especially over the past few years, is a certain degree of disquiet over the overall effectiveness of competition tools, especially traditional competition tools. I think one of the observations that you can make about digital markets, right, that they are characterized by basically one key characteristics is the fact that they are dominated by big players. I think if you look at the report which issued by the PricewaterhouseCoopers earlier this year in May, talking about the global top 100 companies by market capitalization, 8 of those 10 companies are currently provide digital products or services. And I think the typical concern would be that when you have a market with many or with large players, these large players can operate potentially unilaterally, independent of competition, potentially in a manner which excludes competition and ultimately affects consumers. The concern, I think the traditional competition response has been to rely on a certain type of regulation tool called abuse of dominance or anti-monopolization laws. And these laws are ultimately concerned about the excessive use of market power to the exclusion of competition. And I think the main challenge, as it were, when trying to enforce these kinds of laws really lies in ultimately market definition and market power. Because in order to establish abuse, I need to first determine, or rather, let me correct myself, in order to establish dominance, I need to first establish what exactly is the market and whether or not that particular player exercises any power within that market, before then asking the question, is this abusive in any shape or form? And I think when you try to determine markets, when you try to determine market power, thresholds become an issue because typically one of the indicia of whether or not a party exercises substantial or enduring market power is a question of how much market share does it really occupy. And I think that's where we often come into discussions about thresholds and how much market share, how much share of revenue within a particular market does this entity actually reap, and then proceed to then analyze whether or not that is a clear indication of the ability to exercise power on the market. And I think one of the concerns is that market share, although it is an indication, does not necessarily translate into market power, simply because there are other considerations from an economic perspective which feed into the overall analysis. Things like barriers to entry, things like product differentiation, the ability of buyers to switch out if a market player were to suddenly increase its prices. And that leads to, I think, ultimately some degree of uncertainty in terms of whether or not a party can be deemed to be dominant. And once you have that degree of uncertainty, you are also faced with questions about whether or not a decision taken by a regulator will ultimately be upheld if it were to be challenged in the courts. And I think one very recent example of that would be the decision that's been handed down in the Epic Games versus Apple lawsuit, where essentially you could see that both parties were essentially trying to argue different markets. And ultimately, the judge, rather than accepting either party's definition of market, decided on a different, or rather a middle ground approach. And essentially, it reflected the fact that neither party could get it right. And I think that is the problem with trying to rely on some of these traditional competition enforcement tools, because it really depends very heavily on market definition and sometimes the vagaries are associated with economic analysis. And that's also one of the reasons why you see in these recent legislative reforms that are coming up from other jurisdictions an attempt to shift away from discussing or focusing the analysis on dominance or market share. Instead, you see an attempt to refer to other kinds of indicia to determine actually whether or not a particular market player has sufficient scope, sufficient reach to various consumers, to players within the market, to then determine, because of that, the extent of your reach, we will then impose additional ex ante obligations on you. So that's actually I think what I see as a major shift that is happening, and that is also something that indicates perhaps a thinking that although some of the traditional competition enforcement tools do remain relevant, there is a need to basically get ahead of it in order to establish, I think, more significant or sustainable change in the market, and hence you see all these ex ante obligations coming to the fore.
Hey, thanks, Shumik. And I think that's a very good segue into discussing some of the recent developments that's come up from the U.S. courts. Apart from the Epic and Apple litigation, we had a couple of months earlier the FTC and Facebook litigation, right, which also had the same problem of market definition. And I'm going to ask Professor Reed to just kind of like take us through a bit of what you've managed to decipher from these, and share with us the challenges that the courts discovered or shared, right, about market definition. And at the end, I'd like you to give a comment on a couple of points. First, yes, if there is a challenge with market definition, and we are eventually moving to some of these regulations that try to define a certain numerical threshold through reach and maybe even turnover, right? But are we not substituting one difficulty of definition with another difficulty of definition? Because now you need to figure out, are you an intermediary? Are you a gatekeeper? Right, before you can even talk about thresholds, which is kind of like the same for competition, isn't it? You first have to define the market, and then you have to see what market power you have. So anyway, Professor Reed, over to you. Share with us a bit about the US developments and your thoughts on these two questions.
Yeah, no, it's a very interesting and actually difficult issue. You know, I'd like just a couple of hours, please, to get into it and explain it properly. But let's see what I can do in 2 minutes. I think the most interesting read is actually the Apple and Epic decision, though it is 185 pages long, but about 60 pages of the 185 are focusing on market definition. And the judge keeps coming back to market definition and says, you know, well, yeah, okay, this is what I said earlier on. Am I still right? You can see the judge struggling all the way through. And there are so many ways, because of the flexibility of the technologies, there are so many ways you could define the market that in the end, it's almost a political choice as to where you go. Small p political, not party political, but it's a kind of political choice about the direction of society as to where you go. So when I came to the case, when I heard about the Apple and Epic case, I thought, well, it's obvious that Apple is a monopolist for the Apple platform, because it controls it controls the payment service. It must be in a monopoly position. And the judge is saying no, because I think the market is wider than that, based on concepts that, to be honest, don't translate. The idea of substitutability. So there's a long discussion by the judge about, well, you know, people could get rid of their iPhone and buy an Android phone instead if they wanted to do this. They could maybe go and play it on a different platform. And it's quite clear to me that the judge is looking at the theoretical possibilities rather than what people actually do. So I think the big problem with market definition is that it comes from a sort of theoretical economic basis, and it focuses very much on percentages and numbers. And you still always have this definition problem, because you could define an online services market in multiple ways. You have so many choices. Yeah, in that case, there were 3 choices that the judge pointed out. I could have invented 3 more for the judge to consider. And everybody here, I expect, could find another couple. There are multiple choices. So what's the alternative? Well, the interesting alternative is in the EU Digital Markets Act, and I see that that's also turned up in India, and I think in Japan as well, is to start putting together numerical thresholds, trying to adopt a different test that's divorced from economics. And the test in the EU for the Digital Markets Act is 45 million monthly users plus a market capitalization of 65 billion euros. Anyway, there are objective numbers that we can pick up there. And in that case, there's then a list of things that qualify you as a gatekeeper. So if you are performing these activities and you meet the thresholds, you are a gatekeeper. So it's an attempt to have a very objective justification. You know, are you doing these things? Yes. Do you reach the thresholds? Yes, then you're a gatekeeper and the regulation applies to you, which is much easier to have some idea in advance about whether it applies than taking the standard competition law tests and trying to do the economic analysis. And I think there may be some justification for it, because if you think about where the problem arises, the problem both for the competition side and the immunity side arises because these big players have control over two important things. They have control over access to users, and they have control over the information about users and about users' activities. And the antitrust problems arise from the way they use those, inevitably, to try to maximize their income. They use that control. And the immunity problem arises because lawmakers look at it and say, well, if you control access and you control data about what they're doing, why can't you control content as well? Not recognizing that that doesn't necessarily connect and creates other problems. But in the antitrust field, because it is very much based on control of access and control of information, and then the use of that to maximize profits, that fits very well into the reasons behind antitrust law in the first place, and I think gives an easier way of defining whether or not it applies. The interesting question, I'll stop now, is the political one, of course, which is where you set the thresholds. And I like Malavika's comment that the Indian threshold is set just low enough to capture WhatsApp. And I'm sure that's how it's done. You have a list of the providers you want to capture, and the threshold is set below that.
Yeah, and I think on that, I'd like to just invite both Malavika and Takashi to come in to talk about this, because I think Takashi comes already in Japan, right? They've taken a slightly different approach. They've actually specified the platforms. But perhaps you could share a bit about how METI went about identifying which platforms that they needed to specify. I'm pretty sure there was a certain definition, and I'm pretty sure that there were thresholds as well. Takashi, do you have anything to share?
Yeah. As I introduced, there is a much very clear standard on the threshold issued by METI, and to determine that standard, METI made a very big research and listened to the online shop operators and also now Apple stores producers, because there are many troubles. It was reported that, and so the government assumes METI finds it is a very urgent situation to solve the problem between those operators and digital platformers. And determined those 3 and 2 companies should be targeted as this time current TFDPA. So if they found many other troubles between other platformers, they can change the definition of the standards under the TFDPA in the future.
Yeah, thanks. And that's a different approach. Gives same amount or perhaps even greater certainty, because instead of just activity and threshold, METI does the market research and then tells you, I'm specifying you are prescribed and you will be under this obligation. Malavika, what about India? You had some things to share here as well.
Yeah, sure. So the way I see it, there are sort of 3 areas of play, and I really like those 2 points around the control of the user access and the control of data. And I think in all of these 3 areas that's at play. My first caveat is I'm definitely not a competition lawyer, so I'm being forced as a data protection and finance person to get into it. And it's very complicated. As you know, there are about 5 or 6 different stages of probes, I think. So therefore, I don't want to comment on thresholds. I know that we have in certain cases a 30% flat threshold when it comes to assessing once you've determined the market, market, but that's also changing when it comes to these kinds of players. But I know that, I mean, one thing I will say about competition, which I feel I can confidently say, is that there is this big question of jurisdiction itself for the Competition Commission of India. Part of that is the idiosyncrasies of, you know, our regulatory structure, but there's really a question of whether it falls within the realm of commercial or economic activity, and how do you size that activity and so on for the CCI to get involved. So in many of these probes that the CCI has launched, in fact, they've been scuppered by the tech companies themselves, then filing a case challenging jurisdiction. That goes on for a couple of years, for instance, and then in most cases, I think they do then continue the probe, but that's one thing that's happening on the side, and it's early days yet. I think the two other areas I was saying, just to clarify, so in the intermediary regulation, that's to do with the safe harbor. So the notified threshold is 5 million, which is actually quite low because, as I said, WhatsApp has 400 million, and many even small intermediary organizations. So this is clearly meant to capture, I'm sure there's a list somewhere with names on it, but I think the way that it's drafted is really, it's very rare for anyone not to be significant intermediary if you're 5 million, right? And therefore you have a lot of these kind of free and soap. One of the cases has been filed by a FOSS developer who is essentially saying that I have this FOSS platform and everybody uses, you know, these kinds of FOSS tools that we've put out, including WhatsApp, to create their platforms. So the question there is, how do you even set a flat threshold? And how did they come up with this 5 million number? So that's one. And the last thing I will quickly say is what we're waiting for is how does significant social media intermediary intersect with the idea of a significant data fiduciary under the PDP bill that's coming, the data protection bill. And what's interesting there is it will also be a flat threshold, but we have in section 26 of the draft bill 5 or 6 factors that will be taken into account when setting this threshold, which is volume of data processed, sensitivity of the data, turnover, risk of harm of processing, use of new technologies, and other factors that cause such harm. So as you can see, that's really going to broaden out the set of factors that's taken into account to demarcate somebody as a significant data fiduciary. And then it'll be interesting to see how the competition regulator reacts, and of course, how the intermediary regulation reacts to that. So I don't know if that's helpful, but that's kind of the view from India.
Thanks. And I think this is one of the topics that when we come back next year, we can definitely talk about this again, because I'm sure there would have been new developments. I'd like to stick with you, Malavika, and move on to our second topic for discussion, which is really around the other area that you can, or rather, you can put a lot of the other developments into this heading, which is fair trading practices, right? It pokes its head up in various aspects. One, when you access to data and use of data, that's something that's coming out of India, right? Second, which is how are you transparent about your terms to the users of your platform, particularly merchants who are using platforms, and that's something that we see also coming from China, the MFN clauses, right? And this prohibition of exclusivity, of you can't force the merchant to choose one service between two, right? So that's another, right? And then the third one, of course, when you have an interest in the market itself, right? How self-preferencing, right? Ranking affiliates and paid advertisers in priority to others. Fair trading practices. So maybe I'll get Malavika for you to just talk a bit about some of these the issues, right? How do you think these will pan out in the coming year with these new moves in India? And then I'd like to invite Royce, right, to also share a bit about the action that he must be deep in, right, in China over these issues. So first to you, Malavika.
Sure. And again, very briefly, it kind of lines up well with the kind of 3 areas that I was just talking about. So I think across all, there's this element of fairness that's being expressed given the jurisprudence of that particular area. So, I mean, to begin with competition, I think probably the most interesting matter, which is just kicking off. Again, there was an information filed by an association called the Delhi Vyapar Mahasangh. They're a group representing small and medium business houses. They filed information with the Competition Authority against Flipkart and Amazon, essentially saying there's anti-competitive practices happening vis-a-vis them and other sellers. And of course, in 2019, they filed it. 2 years later, there were various levels of High Court and Supreme Court decisions on whether the CCI had jurisdiction. So finally, we are kicking off on that right now. I think the question there is what counts as an unfair trade practice or an anti-competitive practice, specifically with relation to deep discounting and data for targeted sales and preferential listing and so on. So I think there, the idea of creating vertical restraints, as I understand it, is what is going to be the focus of the unfair trade practice kind of discussions by the Competition Authority when it comes to it in the next couple of years. When we move into kind of consumer protection, I think this is where it's most ripe for further challenge, because we've always had digital services sort of counted as part of the Consumer Protection Act. We had a new act in 2019. And these rules are very, very new, and they have the consumer protection e-commerce rules that I mentioned. They are extensive. They go into actually almost listing out what kinds of unfair trade practices you can be thinking about. And I could provide examples, but I suppose once we have the new amendments to the 2020 rules, what we have then is a kind of enforcement structure through a series of tribunals that exist. So you can actually see consumers going to these tribunals at the state and the national level and actually saying, and that'll be interesting to say, because we have a very, very small set, but a strong set of consumer digital rights organizations. So I kind of see that's where there's going to be a line of probably jurisprudence coming out. And then, of course, the big one is in relation to fairness, not on commercial terms, but fairness in terms of data use. And this is going to be interesting because I think the regulator to be will have a larger role to play. In India, we have this concept of a data fiduciary. And so that's bringing fairness in from very different from unfair trade practices in the commercial sense. It's bringing fairness in from, fiduciary responsibilities. And it's using this example that even as a data fiduciary, when you are using certain types of data, even if you've established grounds, you must still use them with an obligation of fairness. So there's a new obligation for fair processing. And there's a question of what will fair constitute there, because you have this fiduciary level and their fiduciary responsibility. And there again, we have an enforcement system where you'll have a new regulator who can directly seek information and create in everything from informal guidance right up to quite significant fines where it's not considered fair. So I think those are the kind of areas of movement. One is traders actually going to the Competition Authority. You could have consumers going to the consumer forums, which are also very new. And then, of course, I think the data protection regulator, how it coordinates with these two forums is going to be interesting to see, because in some sense, they don't need to have a commercial lens to their assessment at all.
No, it'd be interesting to explore this idea of data fiduciary review on some other panel, because usually when we talk about fairness in terms of data, it's about bias representative, whether the data set is representative, right, and whether the prediction the prediction or the recommendation has been skewed by the presence of anything in the data sets, right, that shifts it one way or another. But very interesting concept, marrying the idea of fiduciary to how you use the data and not just whether the data itself is representative. Now, with that, I'd like to give Royce an opportunity to chip in, right, and talk to us about in China, we've heard a bit about what you shared about the MFN clauses and all that, right? So what's your take on what's going to happen over the next few months? Very exciting times over there.
Sure. I wouldn't use the word exciting as a descriptor. I think it's quite hellish times right now for many of my colleagues handling the day-to-day trench warfare. In terms of understanding the regulators' concerns, what the objectives are, and then really working backwards and putting in place the right compliance programs to the satisfaction of the regulators. As you may know, as part of the fine that we received, we do need to put in place a compliance program, and we do need to report regularly in terms of the reforms that we need to make to our trading practices to ensure that we are aligned with the needs of the state. I do just want to point out very quickly a couple of perhaps more salient developments, I think, which in a way dovetails very nicely with the earlier discussion about dominance thresholds, because one part of the guidelines issued for the platform economy issued by the State Council deals precisely with that issue. And quite clearly, they reserve the Chinese authorities, they reserve the discretion to, in certain circumstances, do away with the need to really define the relevant market, precisely because of the conceptual difficulties of identifying or defining or delimiting the boundaries of what the relevant market might be in the platform sector. Instead, the focus turns to certain prescribed behaviors that are considered to be abusive or to be harmful to competition and or harmful to consumer interests. Some of these include unfair pricing, selling before cost, refusal to deal with merchants, exclusive dealing, tie-in sales, or imposing any other unreasonable or discriminatory trading conditions. So this provides a very big leeway for the authorities to come in and to find that a platform might have tripped up because it engaged in a sustained manner, especially some of one or more of these prescribed behaviors. Another new development is the concept of essential facility. I think in the platform economy, a platform can be considered an essential facility if we refuse to deal with merchants who want to use the platform and we do not have good justifications in not wanting to deal with them. So again, this is a very significant threat that really puts the onus on the platform to display a certain neutrality, love all and serve all ethos. And to determine whether a platform constitutes an essential facility, then they would consider factors such as the data that the platform occupies, the substitutability of other platforms, the existence of potential available platforms, and the feasibility of developing competitive platforms or any barriers to entry, and the degree of dependence that merchants have on the platform. And to be fair, also the possible impact of opening the platform on the platform operator itself, although it remains to be seen how this bag of measures would ultimately interact and how that would play out. You also touched on the MFN clause that I mentioned in my earlier presentation. Another interesting aspect is that under the measures on supervision and administration of online transactions issued by the SAMR, there are also requirements in terms of platforms not imposing unreasonable restrictions or conditions on merchants' transactions, transaction prices, and their transactions with other platforms, such as forcing sellers to choose to pick one from two, lowering their search results, delisting their products from the platform, restricting their operations, blocking their services, or increasing their service charges. So again, a very strong indicia towards the need for platforms to operate with sufficient neutrality and objectivity. Perhaps one last point I want to touch on is the draft provisions on the prohibited acts of unfair online competition, where one of the prohibitions is against the use of technical means to carry out other acts of unfair online competition. And within this very broad heading, one of the prescribed behavior is that business operators must not use technical means to illegally capture or use other business operators' data to create an actual replacement for the content, full or otherwise, of the network products or services lawfully provided by these other business operators. So clearly, another constraint on the kind of usage that platforms can employ for the data that it has on the merchants. So I think that the story is still being written. It's been a very busy year for Alibaba, as well as other platforms operating in China. There's been this deluge of new regulations, like I shared in my earlier presentation, both in terms of degree and as well as in terms of the depth. So we are still in the adjustment period. The hope is that once the dust settles, we would enter into a new normal where the boundaries of prescribed behavior is clear, and that we can then compete on a stronger footing, a more transparent footing.
Thanks, Royce. And I'd like to. I have no choice but to draw this panel discussion to a close. As you can see, this is a fairly typical Tech Law Fest discussion, right? We are always at the cutting edge. We start off in an area that was sleepy for a couple of decades, right? Since 1995, right? Talking about immunities and safe harbors, And then we see in the last 5 years or so a convergence between regulation of intermediaries with competition law and with consumer protection law, right? And that is still happening. How these tectonic plates are going to eventually settle, and what the final landscape is look like will look like, as Roy says, the story is being written. And one of the things that we really should take away from this is that it has been a fundamental change in the role of intermediaries, bringing about these tectonic shifts. They are now being recognized as gatekeepers. They are now being recognized as the ones who are sitting on top of data, and how they ought to also have certain responsibilities about how they use the data, drawing on this concept of fiduciary that India has, right? And of course, right, to make sure, right, that they are able to behave in a way, right, that doesn't put themselves in a conflict of interest in the market that they actually operate, because fundamentally their role is in intermediation in a two or multi-sided market, right? So with that, I'd like to thank all my panelists, right, for an interesting time. I hope the audience have also found it insightful and educational. I have definitely. Every time we speak, we learn. I learn something new, and I hope that I'll see everyone back again next year for a continuation of this discussion. Well, thank you, everyone.